Hi there, I'm Savannah Mexto with Mannor Law Group, and I'm excited to welcome you to another webinar Wednesday with esteemed elder law and estate planning attorney, Robert Mannor. This week, attorney Bob Mannor is addressing a serious topic that, honestly, many of us try to avoid. What happens when you die without a will? It can be uncomfortable to discuss, but understanding what this could mean for your loved ones is critical. Before I pass the mic to Bob, I'd like to cover a few housekeeping details. First, note that even though Bob is an attorney, today's webinar will not give specific legal advice. If you have a question about your unique situation, please contact us after the webinar. Also, if you do have a general question during today's presentation, please use the chat box. We will save time to review questions during the webinar. And if for some reason we don't get to your question, we will contact you after the presentation. Lastly, note that today's presentation will be recorded and the replay will be sent out tomorrow so that you can re-watch it or you can share it with family, friends, or anyone who you think could benefit from hearing this information. Now, why should you listen to what the folks at Mannor Law Group have to say? Note that we are a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Mannor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. Bob is also a leader among elder law attorneys, and he's currently chair-elect of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. Lastly, Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome attorney Bob Mannor.
Hi, folks. This is a great topic, and we're going to get right into it. So, what happens if you die without a will? So, I saw this little cartoon up here that I thought was kind of cute about this is what it looks like when you have no planning and you're sawing off the limb that you're sitting on. And very true when it comes to not having a plan in place. So we're going to talk about this and talk about what happens and why it's really important that you don't just let the default happen and that you at least do minimal planning, which is a will and powers of attorney and healthcare documents and all of that. So the quick answer, I was tempted to put this on my slideshow here, is the quick answer to the legal question of what happens when you die without a will, is the same answer to any question you ever ask a lawyer. This is kind of a joke among lawyers, but it's true. It's actually a true joke. The answer to any question you ask a lawyer is, it depends. That's true. Honestly, if you ask any question to a lawyer about the law, the answer is always going to be, it depends, because it depends on the circumstances. It depends on the facts of the case. It depends on what's going on, okay? And so we're going to talk about some of the it depends. So let's kind of start going through this, and we'll talk about this from a standpoint of the different situations. So what happens if you die without a will and you're married? Well, of course, my answer is it depends. It depends on a lot of circumstances. So most people would assume if you die without a will and you're married, everything just goes to your spouse, right? Not necessarily, okay? So what happens if you die without a will is going to depend on how assets are titled and how we have beneficiary designations. And there's going to be three distinct things that's going to tell us what's going to happen to your stuff if you die without a will. And the first one is going to be if there's a joint owner on there. The second one is going to be if there's a beneficiary on there. And the third one is what's called intestate succession. And that's that the state of Michigan has written a will for you. And it may not be what you want. You're letting politicians decide that. You're letting the state of Michigan decide how things would go and who would be in charge and all of those types of things. And so that's the idea behind this. It's going to depend on the nature of the asset, the type of asset, and whether or not you have a joint owner. So frequently what we see with a married couple is that the spouse is on everything or is the beneficiary. So if you own a house together and one of you dies, what happens to the house? It goes to the surviving spouse. But occasionally we'll see this where the house is actually only in one spouse's name. What's going to happen when that spouse dies, even if they have a surviving spouse? And the answer is it's going to go through this legal process called intestate succession, meaning the state of Michigan has basically written a will for you. The state of Michigan is going to decide what happens to that house. Now, the spouse, the surviving spouse, is going to have rights. They call them spousal rights. All right, and there's intestate succession too. So there's a pretty good chance, depending on the value of the house, that the spouse is going to end up with most of the value of the house. But that's not guaranteed, depending on the circumstances and whether the kids are from that relationship or from that spouse or not. And so there's a good chance, but here's the problem. It still has to go through probate. So if your spouse died suddenly, you're living in a house, it's been your house for 20, 30, 40 years, but your name's not on the deed, you'd have to go through probate just to confirm that you can stay in that house, right? That's not an ideal situation. And so that's a problematic situation if only one spouse's name is on the house and there's not some reason for that, like the other spouse has dementia or Alzheimer's or something like that. So, but that's not a guarantee that it's going to go to the spouse. There's going to be a lot of factors that go into it, and there's a division of assets that goes through this intestate succession. Why we frequently think that it's going to go to the spouse is because it's not about intestate succession. It's not even, frankly, about the will. It's about the fact that the spouse's name is on the deed, right? So if the spouse's name is on the deed, then it's going to go to the spouse. If the spouse's name is on the bank account, then it's going to go to the spouse. If the spouse's name is the beneficiary of the IRA or the 401k, then it's going to go to the spouse. This is, although it's probably what the decedent intended, the person who died, it's probably what they intended, it actually has some consequences we need to think about, and why not having a plan can cause all kinds of heartache and all kinds of problems. So let's say this is just a second marriage. Let's say you have his kids and her kids. What I see frequently is folks come in and they say, you know, yes, this is our second marriage, but we've been married for 30 years. I want to make sure my spouse is protected. So if I die first, I want to make sure my spouse is protected. So their name's on the house, their name's on the bank account, they're a beneficiary of my IRA, and that's fine. And so when I die, all of it's going to go to them, correct? Yes. All right, so I have another question for you. What happens when the second spouse dies? What happens when the surviving spouse dies? If you don't have a will, or even if you do have a will, what's going to happen? It's going to go according to their terms. It's going to go according to their will. It's going to go according to the intestate succession as it relates to them. So if you have children from a previous marriage, previous relationship, your kids will get cut out of that completely. Not because you intended it, not because your spouse intended it, right? So a lot of people say, oh, I'm not worried about that. I trust my spouse. She wouldn't cut out my kids. He wouldn't cut out my kids. They don't necessarily have to. It's by operation of law. This is where the failure to plan, it creates a big problem and creates years and decades of family strife and arguments and hurt feelings and believing that, you know, that their parent's spouse is a bad person, believing that their parent was a bad person for allowing this to happen. You know, sometimes we lose copies of photo albums, we copy things that have emotional value. Certainly just the fact of kind of a slap in the face to say, oh, you know, you're left out. Now, some of the things that people will often believe is they say, well, my dad died. He's married to somebody new. It's not my mom. And so therefore, I should get an inheritance now because my dad died, right? Often that's not the case. Again, it's going to depend on the nature of the asset. Is there a joint owner on that? It's going to go to the joint owner. Is there a beneficiary on it? It's going to go to the beneficiary. Is there a, if it goes without a will, even if it's in dad's name, most of it's still going to end up going to the spouse. Not all of it, because there are some family rights and things like that, but through intestate succession, a good portion of it's going to go to the spouse anyway, even if that's not what was intended. Okay. So I'm going to stick with this if you're married section for a little bit longer, because one of the things I frequently see, and something I would, recommend, is that if it's a second marriage, if it's a later in life marriage, that before you get married, or even sometimes after you get married, you can do this, you have some kind of agreement. They're often called prenuptial agreements and things like that. Not because you're planning for divorce, but you're planning that one of you is eventually going to die, right? Here's the problem with that. We've got a big problem with that, because I see people come into my office all the time with prenuptial agreements, and it's not worth the paper that it's written on. Why? Because they got the prenuptial agreement when they got married in 1998, and they've been married for 23 years now. And so what happened over that 23 years? Well, they each started with their own house. They sold their houses. They bought a house together. Okay, where's the house going to go? To the surviving spouse. They decided, well, we have a house together. We have a bank account together. Okay, so where's that bank account going to go? To the surviving spouse, because it's a joint owner. They say let's say it's the wife that dies first, just to pick on somebody. So the wife dies first, and she had a 401k. She had an IRA. Well, she said, well, we've been married for 22 years. I don't want my spouse to be impoverished. I want them to have access to. I don't think they will be. They have their own money, but I'm going to list them on my IRA. I'm going to list them on my 401k as a beneficiary. Where's that going to go? Does it matter what the prenuptial agreement said? Nope. Does it matter what their will said? Nope. It doesn't. Those legal documents aren't going to overcome joint property. They're not going to overcome a prenuptial. The legal agreement, the prenuptial agreement doesn't have precedence over joint property. Doesn't have precedence over beneficiary designations. Okay. So if you really want to make sure that it's going to go the way you intended it to go, we've got to do more planning than that. We can't rely on that prenuptial agreement, because what people often do is they have a house together. Okay, well, we got to plan for that house to say, well, where's that going to go after we both die? We may want to make sure that either one of you have the right to live there for the rest of your life, and maybe even put some flexibility into that. But what happens afterwards? Are we going to say we're going to roll the dice and say whoever lives longest, their kids get it? Because that's what most people do. That's what you're doing when you haven't planned. If you haven't planned, you're cutting out one side of the family. You're cutting out one spouse's kids. Guaranteed. That's the way it is. If you don't have a plan together, because it's whoever lives longest, they're the ones that are going to receive that asset. Their kids are going to be the ones that receive that asset. So it doesn't matter if you had a prenuptial agreement. It doesn't even matter if you had a will. We're going to have to do more planning than a will in that situation. Okay, so what if you're not married? What if your spouse has already died? Well, again, the state of Michigan has written a will for you. This one is going to be a little bit more obvious. You really don't want to have this in the event that you're married. You really have to do good planning in the event that you're married. If you're single, it's going to be a little bit more obvious. It's going to go, if you don't have a will, it's going to go to what the state describes as your next of kin. So if you have children, it's going to go equally to the children. Now, I was meeting with a family today, and Dad had it set up this way that it was going to go equally to the children. But it wasn't really planned for in a very thorough way. Well, what's the problem with that? That's what everybody wants, right? You go equally to the children. Well, one of the children, so Dad was elderly, and one of the children, her spouse, has severe Alzheimer's. Is that good? I mean, is that good that she inherited this property? Well, I mean, it's good that she inherited the property, but now that asset, that inheritance she got from Dad, is exposed to her husband's Alzheimer's costs and her husband's medical expenses. And if we had set it up right, it wouldn't have had to be. We could have made sure that she got the value of it, but it wouldn't be exposed, that he could get other resources to pay for his home care, to pay for his nursing home care if it ever got to that point. Okay, hopefully it won't. Hopefully he doesn't have to go to a nursing home, but it could pay for home care and things like that without having to spend down that asset first. Well, unfortunately, Dad didn't plan well enough, and so now it's going to go into her name, and that means it's going to be exposed to her husband's illness or his husband's medical expenses. So if you're not married The state of Michigan has written a will for you. That's a little bit more obvious that it's going to go where it's supposed to go, which is your next of kin. So first it'd go to kids, then it would go, if there's grandkids, if the kids have died, it would go on to grandkids. If there's no kids or grandkids or great grandkids, then we look up. We say, are your parents still alive? Then it would go to your parents. If your parents aren't still alive, then it goes sideways. It goes to brothers and sisters. If your brothers and sisters aren't still alive, it would go to nieces and nephews. If there's none of that, then it goes to first cousins and so on. And there's this whole list of where it would go in the event that you're single and you die. Now, again, that's only if it doesn't have a beneficiary designation on it. It doesn't have a joint owner on that. Okay, that's where the state has written a will for you. What about if you have real estate? So real estate is a little bit different because you can't put a beneficiary designation on it, and you shouldn't put a joint owner on there. Okay, I'm going to say that again. You should not add your kids to the deed to your house, period. You should not add your kids to the deed to your house. And I know I said that 3 times now, but it's so important that that's the case. It's going to cause all kinds of harm, all kinds of problems, all kinds of tax issues, all kinds of real estate issues. I had a conversation with a real estate attorney recently, and we were talking about people adding their kids' names to deeds or even using ladybird deeds. And he said, well, the most of the time when I see that and the parent has died, I just automatically prepare a court action. It's called a partition action. So he just assumes it's going to end up in court if we have added kids' names to the deed, if we have a ladybird deed where it goes to the kids. He just assumes it's going to end up in court because it happens so often that it ends up in court. And there's a lot of reasons behind that. It's a really bad idea to add your kids' names to the deed to your house. And I can give you, I have 2 other webinars that I've done. So you can look back in our list of webinars and you can see I did one, well, I've done 3 actually. I've done one on bad deeds and how deeds can be easily create all kinds of problems because of one word different or a comma in the wrong place, or you trying to explain something in plain English, but lawyers don't use plain English, right? Okay, and so I have a seminar or workshop on that, a webinar on that. I did one with some realtors, and I had a realtor and a title company on the webinar, and we kind of all talked about how these types of mistakes get made all the time. We see it constantly. At least once a week, I see a bad situation created by somebody adding their kids' names to a deed to the property, or even using a ladybird deed. So and then I have a 3rd webinar that I talked about why you shouldn't, specifically about why you shouldn't add your kids. So I'm not going to spend all the time on that, why you shouldn't add your kids' names to your property, but I do have other presentations on that. One of the things that people will often forget about is mineral rights, okay? Oil, gas, or mineral rights. So why is that different? Well, oil, gas, or mineral rights can be separated from your ownership, your other ownership of that property. So this happens a variety of ways. One is that you inherited it. You got it from your grandpa, you got it from your dad, you got it from your uncle, whatever it is. You just got these mineral rights, and they send you $50 every so often, or they send you $100 every couple of years, or whatever it is, and you got these mineral rights. Well, guess what? That's a real estate interest. And so we're going to have all kinds of trouble and have to go through probate, go through all of this hassle after you die if we don't plan for that properly. Even if it's only $50, even only if it's $100 every couple months, whatever it is, that's going to be an issue. It doesn't automatically transfer to your kids or even your spouse. We might have to go through probate just to get it to go to your spouse. Okay, so that's the one way. You've inherited a mineral right. Okay, the second way is that you had property. It had a well or a lease on it for mineral rights or oil rights or whatever it is, and you lived there and you sold the property, but you retained the mineral rights. You said, okay, I'm going to give this property, I'm going to sell this property. Somebody else is going to live there. That's their property now. But if there's ever any oil there or mineral rights there, or anything like that, I'm retaining that. Well, that has to be passed on through a real estate interest too. You can't have a beneficiary on that. You shouldn't have joint owners, although that's less problematic than having them on the deed to your house or things like that. The other example is a house without real estate. So most of the time, when real estate law, when you talk about how the law treats it, the law says if the house is attached to the land, the house goes with the land. And so it's the deed to the land that tells you who owns the house. You don't have a separate deed for the house, okay? Now there's an exception to that rule, right? And so mostly it's going to be, modular or mobile homes where you're paying lot rent, okay? So you don't own the land, you pay lot rent, you own the building, and but you don't own the land. Well, that's going to be problematic too if you don't have a plan for that. And the answer to that question is that actually transfers, the transfer of that doesn't occur, it can happen where it has to go through probate and all of that, but the transfer occurs at the Secretary of State, not at the Register of Deeds. Because if you only own the building and you don't own the land, then that's going to go through the Secretary of State. It's like a car title instead of like a real estate deed, because you don't own the dirt. You don't own the dirt that it sits on, and that's going to be a different scenario. We've talked about this, these next 2 bullet points here. If you have a beneficiary, that's going to override you not having a will. That's going to override even if you have a will. Beneficiaries are going to take precedence over your will or no will. Joint owners are going to take precedence over your will or no will. I will frequently have folks come into my office and they'll say, well, I have this life insurance and I'm listing my son on there as the beneficiary of that, because what he's going to do is he's going to pay my debts and then he's going to divide it up. Nope, that's a really bad idea. That's going to cause all kinds of harm for your son. He may have some gifting issues with that. It's, that's going to be considered his asset. First of all, he may not actually pay your bills. He has no obligation to pay your bills. He has no obligation to divide it up between the family members. He has no obligation to follow the terms of your will because you left it to him. Doesn't matter if he's the executor. If you leave it to the executor, that's a different thing. But if you leave it to him as a person, so your son is named John Doe, and you leave it to John Doe, that's his money. He has no obligation to pay your bills. He has no obligation to divide it up among his family members. And so I can hear what you're thinking. I can't see you, but I can hear what you're thinking. And what you're thinking is, my son would never do that. Well, I've been doing this for 25 years, and I've heard parents say that for years, and I can tell you, maybe, maybe not, okay? Money does strange things to people, especially after the parent dies. But let's say that they do. That's going to cause your son problems. If you leave it to your daughter, it's going to solve your daughter problems because she has legal ownership of that. And if she transfers it to the others, she may have some tax issues, especially if it's like an IRA or any type of retirement fund. She's going to be in really bad shape. He's going to be in really bad shape, whoever you leave it to, because they're going to have the tax burden and they're giving the money away to others. All kinds of problems with that, okay? And it's not easy to divide up the tax burden. It's not that simple. It'd be really complicated to try to figure that out because everybody's in different tax brackets, right? So it's really difficult. You're trying to do the right thing and make it easier for them. You're making it so much harder for them. So much harder for them. It's going to cost way more money to settle this. And what ends up happening is your son or your daughter, who you had to go to, ends up eating the tax bill and giving the money away and getting hurt by it. So the person that you trust the most, that you're putting in charge of it, is the one that gets hurt by it. So really bad idea with regard to that. So that's even using beneficiary designation. Much better to have a master plan, to have an estate plan that really says, okay, this is how it's going to go, and we're going to make sure that the people that you put in charge aren't going to get penalized for trying to do the right thing, and that it's actually going to follow those terms. All right, so this is, I know a lot of people say, hey, I want to make this simple, right? I just want to make this simple. It should just be simple. Well, guess what? That's not the way the world works. That's not the way the law works. It can be simple if you have a plan. It can have a simple result if you have a plan. It costs a little bit of money, takes a little bit of your time to do a plan so that you're not sawing off the tree limb that you're sitting on, right? And so the problem is if you don't have a plan, very good chance that you're going to be hurting the people that you trust the most, that you're trying to make it easier for them. You made it harder for them. Joint owners are going to make it harder for you. Why do we not want to use joint owners? Why would we want to put a legal plan together, an estate plan together, rather than just putting people's names on it? Because that's going to hurt you. Because if they ever have any problems, your money, your house is exposed to their problems. So here's the scenario. You've got a wonderful daughter. She's just a wonderful person. And so you decide to put her name on the deed. You decide to put her name as a co-owner on your bank account and other assets. Beautiful, wonderful person. She calls you every day, goes through a divorce. She has some problem with her spouse. What happens? Your money is exposed to that divorce settlement. She gets sick. Her husband gets sick. Her spouse gets sick. Your money is exposed to her illness costs or her spouse's illness costs. She has some financial trouble. She loses her job. Your money is exposed to her debt. She runs up credit card bills. Your money is exposed to her debt. Don't put joint owners on it. Don't put her name on it. She may be financially well off today. We don't know what's going to happen tomorrow. You know, if anything has told us about the last few years is it's not possible to predict what's going to happen. And even if they're a business owner and they've always made good money, is that going to continue? Are they going to have some troubles? Are they going to have a lawsuit? Are they going to get a car accident and get a lawsuit because of that? Your money, your house, your investment could be exposed to something bad that's happening to your daughter or son. Don't put their names on it. That's a really bad idea. Okay. All right. So I have a couple other things I want to talk about. We talked about the second marriage problems. So let's kind of talk about this a little bit further. I want to go a little bit in depth about the second marriage problems. So one of the things that we have to think about is to say, okay, well, how do we solve this problem? So you die, and maybe it goes to your spouse if their name is on it, or they're listed as a beneficiary, or it goes through probate and then goes to your spouse. But then what happens after your spouse dies? Well, a couple things could happen. They could have remarried all your stuff, and then they die, leaving a surviving spouse for them, somebody you've never met before. Now your house, your investments, your savings, your 401k may end up with somebody you've never met. Your picture book, the pictures of your kids when they were babies, you know, their high school diplomas, whatever it is that you have that you've been keeping for your family, it may go to some stranger because you die first, your spouse remarries, and then they accidentally leave everything to their new spouse. You lost your family get cut out. Okay. So how do you prevent that? Well, we have a plan. Okay. We have to have a plan. We say, okay, yes, I want to make sure that my spouse, who I've been married to for 22 years, isn't impoverished if I die first. So I die first. I want that money to be available to them. But if they don't use it, they don't need it, I want it to end up going to my kids, not her kids, not your spouse's kids. Okay. And there's a way to set that up. That's called planning. It's not going to work if you don't have a will. A lot of people just say, I just assume it's all going to work out okay. No, it's not. That's like sitting on a limb and sawing it off, right? That creates a problem. The final example I want to give is what I call the persistent case of bad deeds. I believe it was last week. I don't know, Savannah, if you remember if this was last week or a couple of weeks ago, but I just recently did a presentation where I talked about the persistent case of bad deeds. I think it was last week because it was about ladybird deeds. And so every week I'm looking at a poorly written deed. People think that these are simple. I had one of our favorite clients called us up recently and told us that the Register of Deeds was handing out form deeds that they could just fill out, get notarized, and turn back in. Such a bad idea. One of the things, so I've trained up a bunch of attorneys, right? Not only because I've hired them, but because I do presentations and teaching through the Institute for Continuing Legal Education to other attorneys. So I've trained up a bunch of attorneys, and particularly ones that have worked for me. Some of them are right out of law school. And one of the things that I will quickly say to them, one of the first things I'm going to make sure that they have imprinted in their brain is one of the quickest ways to commit legal malpractice is through deeds. Why? Simple, what seems like a simple deed, right? Why is there so much legal malpractice? Why is there so much bad deeds written by non-lawyers that cause all kinds of harm, all kinds of costs, all kinds of extra taxes, all kinds of court processes that were unnecessary? It's because that simple 1- or 2-page deed can cause all kinds of problems if it's not written so precisely. I was literally talking about whether there's a comma in the right place, or if you use the right, wording, and you don't use plain English. If you use plain English, it's probably going to be wrong, right? I didn't write the rules. This is just the way that it is. This is the way the law is, and I see bad deeds every single week. People bringing in their existing documents. This is especially true in the farming communities. So farmers are notorious for saying that, transferring property to their kids or transferring it between family members or even with neighbors. They say, you know what, let's trade. I'm going to add, this 50 feet of the property. I want to transfer it over to you. You transfer this over to me. And they just write their own deeds. I can't tell you how much money that I've had to charge people to fix those problems, to go into court to fix those problems, to prepare new deeds, all those types of things. Deeds they're so easy to make mistakes on them. So easy to make mistakes. People should never be drafting deeds on their own. And this is something that I warn lawyers about, especially young lawyers about, is, don't take these deeds, don't make so that you don't take them seriously because they look simple, because they're 1 page or 2 page. It looks like you can just fill out a form. I'll tell you what, it's so common in our office that we have to fix poorly written deeds. There would be no way for the average person to look at it and realize that it's poorly written. Okay, so that is the presentation. The bottom line is, I'm going to actually go back to this other slide. What happens if you die without a will? It's going to depend on whether you have beneficiary designations. It's going to depend on whether you're married. It's going to depend on whether or not you have any joint owners. And then if none of those are true, then it's going to end up, because the state of Michigan has written a will for you that may not actually be what you want to accomplish or where you want it to go. Final thing that I want to express one last time is, don't add your kids' names to deeds. It's a really bad idea. It's caused lots of heartache, caused lots of families to fall apart and argue for the rest of their lives. And it's cost lots of legal fees and court fees to fix those problems. All right, so that is my presentation for today. Do we have any questions? If you have a question, you can write it in now. Savannah, do we have any questions pending?
I do not see any questions that have come through.
Well, I'm going to turn it over to Savannah, and she's going to give you instructions about how to get your questions answered and how to get in touch with us to make sure that you have a good plan in place and that you're not sitting on that limb and falling off the limb. So thank you for coming today, and Savannah's going to give you the information about how to get your questions answered and how to get more information.
Thanks, Bob. And thanks everyone for joining us today. As Bob mentioned, we do have an easy way for you to get started working with our team, or even just contact our team for general information. So of course, you can always give us a call. I've put our phone number in the chat box. That phone number is 810-694-9000. Now I'm also going to be sending you an email in the next maybe 10 minutes. That email will have a link. When you click the link, it will take you to a calendar, and you can choose a day and time when a member of our team will give you a call. So, sometimes you're just busy right now. Oh, I just watched the webinar. I don't have time for a call. That's not a problem. We can schedule that call. So again, that email will be coming to you in about 10 minutes. You can click, choose the day and time from there. The call will last maybe 15 minutes. We'll get information from you about your situation, answer your general questions, and then you can ask us questions about our firm, general questions about your situation. And then if you decide to schedule an appointment with an attorney, we can do that from that phone call as well. So I do encourage you either to schedule a call or just give us a call at 810-694-9000. Thanks again for joining today, and we will see you next week.